Welcome to Hull and Estates and Succession Planning, a series of podcasts hosted by Hull and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull and Estate and Succession Planning. You're listening, and some of you may be watching, episode 183 of our podcast on Tuesday, October 7th, 2009.
Hi, Suzana.
Hi there, Ian.
All right, so getting back to our mini-series, and our focus, our client-centered focus of this series is to put the client in the room and sitting across the table from us and seeing what it's like to live and breathe a piece of litigation, and in particular, power of attorney litigation. So what we'd like to start with, and it's always a helpful starting point we find, and not in all cases, but with this kind of litigation, when there's a fight over a power of attorney, so to speak, or guardianship, to go back to first principles and talk about what the Act says, because of the fundamental expectation that you must have a finding of incapacity before the court is really going to engage. And the court's just, generally speaking, that's a bit of an overstatement, but generally speaking isn't going to step in until you have a finding of incapacity, i.e. you're coming to the court dealing with someone who is incapable.
That's right.
And whether they have a power of attorney or they have a guardianship, either way. So let's talk about, let's describe at this point, first for someone without power, without a capacity to deal with his or her own property. And in Ontario, we have the Substitute Decisions Act, but most jurisdictions have similar legislation where they define what incapable means with some precision.
That's right, Ian. And here in Ontario, and we'll have a slide that will actually include the definition of what incapable means that you'll see shortly on our podcast. But in Ontario, we've got Section 6 of the Substitute Decisions Act that defines when someone is incapable of managing property.
So Section 6 of the Act, the Substitute Decisions Act in Ontario, specifically provides what the test for capacity is. Suzana, what are the exact provisions?
Well, it's actually saying that a person is incapable of managing property if they're not able to understand information that's relevant to making a decision in respect to their property, or they don't understand the reasonable consequences of not having made a decision. All right.
So that act is now what's going to prevail in terms of the fundamental test for power of attorney over property. And the act deals with scenarios where someone is reluctant to get an assessment, whether they will be assessed or not, and that's a whole other provision that we can talk about, Section 72. All right, so the other, now with respect to property, now personal care, again we're going to be testing our technology prowess in our new format. The Act itself specifically defines someone who is incapable of looking after their personal care, and that's Section 45 of the Substitute Decisions Act.
And Section 45 provides that someone's incapable of personal care if they're not able to understand any information that's relevant to a decision that responds to or replies to personal care decisions, or if they can't appreciate, again, the consequences of not making a decision.
So the threshold here in the Act is saying is that we have to have an assessment of someone's ability to make a personal care decision or make a property decision. And the parameters of the Act are set out, and it allows us as an important starting point, but more importantly, it allows the court. So unlike a lot of cases with law and power of attorney litigation, you actually have some starting point that the judge can work from. And what they'll do is, in terms of the actual threshold, now that we've talked about it in legal terms, what does that mean in medical terms? Then typically we'll put to the court an assessment by a qualified assessor, and that assessor is going to use as their starting point, whether the person is capable or not, the actual words from the Act itself.
And I think that's an important point, Ian, because many times we have people come to us and say, well, the family doctor has said that, there's some concerns. And we always have to drill a little bit deeper to see whether or not that opinion is going to hold muster before a court. We certainly respect family doctors' positions, their opinions. They probably are the most knowledgeable. But when you're coming to meeting this legal test, because at the end of the day, what are we asking a judge to do? We're asking them to take away someone's fundamental civil liberties. And judges are not going to do that unless they've got the comfort of a very strong strong opinion that says that that individual does need this kind of protection.
Absolutely. So that whole assessment, and we'll talk about how we get to that in a future podcast. So in summary, I think where we're coming from is this, is that we have a really good foundation in the statute to start at what does it mean to be incapable. We know that the courts are going to be very, very, very reluctant to agree to make a finding of incapacity. So we have to work from the Act and get our good medical advice to make sure that the court is then comfortable to give jurisdiction over this person. And the court, once it's stepped in, then we get into the fight.
Yes.
And the fight typically deals with situations where there's gray area, whether or not they're capable or they're not capable. But we're going to save the gray area for our next discussion and the assessment process for our next discussion in our series. Before we wind up, we'd like to try from time to time add in a little twist to our podcast, and that is we want to recommend books. On our webpage, we have a list of books that we think are terrific, and the link is there, and the link to the books are there. Today we want to talk about an interesting book by Robert Rosen, and it's called Just Enough Anxiety.
Yes, and I love this book because the title just sort of rubs me. The first time I heard it, I thought, like, how can there be just enough? There's always way too much anxiety. We're busy professionals, we're busy family members, we're busy people, and to think that there's ever just enough anxiety, which we always seem to view, or I certainly view, as a negative kind of thing, just made me sort of step back and think, well, what is this all about?
So at this point, hopefully our technology works again and are flashing up on the screen the actual shot of the book itself. Summary, Suzana, and by no means do we want to get into too in-depth of a review of it. First of all, we think it's an excellent book, and we think, as you say, it talks about a really important topic. What are some of the points that the author was pressing?
Well, I think the three nuggets that I got out of the book, Ian, are firstly that change and uncertainty, which sort of leads to anxieties, leads to fear, leads to the uncertainty, that is just a fact of life. So we've got to accept it, and we've got to embrace it, and then once we understand that that is in fact something we've got to deal with, then we're going to look to our external support system to see how we can make it all work together, and we turn it into ultimately a positive, so that we can take that energy which we might view as negative and turn it into a positive thing in our lives.
I think that acceptance of change is so fundamental to managing stress.
It is.
And that's just life. And if people wake up every day thinking that their day is going to unfold exactly as they see fit, and they've decided it's a mistake, and it adds stress that is unnecessary. You have to look at change as part of life as opposed to something you have to fight.
That's for sure.
All right, what's the second one? See if we have time to talk about the second one.
Well, it's about understanding and managing anxiety within yourself. So I think it's a little bit of inner reflection, that self-reflection, where you're looking in saying, yeah, all of this stress, this fear is because I'm anxious. And what is causing that anxious? Well, that anxiousness is coming from within, and so I want to turn it into something that's positive.
All right, and finally, the other nugget that you got out of this?
Is that you want to look to others for support. It's all about the support network, and the truth is, by controlling our own anxiety, we can control our external forces a little bit more, or those around us, and so we can try to get a grip on that, and then hopefully we'll project a positive to the what would otherwise be possibly a negative.
Awesome. Well, again, Robert Rosen, cool book, Just Enough Anxiety, highly recommended, and we look forward to our next podcast where we're going to talk about the power of attorney litigation from the client's chair.
Okay, thanks very much,
Thanks
Ian.
very much.
You have been listening to Hull and Estates and Succession Planning by Ian Hull and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.